My name is Jeff Morgan. I am from Dallas, Texas. In the previous video, I talked a little bit about how in the state of Texas, in Texas family courts and in the Texas Family Code, there is really no due process protection afforded to many individuals. For example, in the case of unilateral no-fault divorce, the respondent to the divorce does not have due process protections. These are protections that are guaranteed to us by the United States Constitution. The Fifth Amendment to the Constitution says this: no person shall be deprived of life, liberty, or property without due process of law. The 14th Amendment says this: no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. Texas family courts, these two things do not apply. Furthermore, if you look at the Texas Constitution, we have Article 1, Section 19, deprivation of life, liberty, property, etc. by due course of law. This is our Texas Constitution. Our Texas Constitution says that no citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disenfranchised, except by the due course of the law of the land. Now, in the Texas Family Code, under Subtitle C, the Dissolution of Marriage, Chapter 6, Suit for Dissolution of Marriage, Subchapter A, Grounds for Divorce and Defenses. And remember, defenses, there really aren't any defenses. So I don't even know why we have grounds for divorce and defenses. There are no defenses for divorce. That's just the reality of it. Because here is a statute that basically covers almost every divorce in the state of Texas. Section 6.001, insupportability. And again, insupportability is nowhere defined. Nobody knows what insupportability means, but somehow this word is going to conjure up some great images here, and we're going to use this word insupportability to somehow take actions under the color of law in which we deprive citizens of their due process protections and equal protection under the law. Insupportability. On the petition of either party to a marriage, the court may grant a divorce without regard to fault if the marriage has become insupportable because of discord or conflict of personalities that destroys the legitimate ends of the marital relationship and prevents any reasonable expectation of reconciliation. Once again, only one person needs to make this assertion. The respondent may completely disagree that the marriage is irreconcilable. The respondent may not even know that there were any problems, and yet the judge always sides with the opinion, the belief of the petitioner. This has nothing to do with the operation of law. This has something to do with the Texas Family Code and the judge taking the belief system of the petitioner. Because if both beliefs were actually weighted equally, there would have to be some type of findings of facts and conclusions of law, which there aren't. And you would think that if there were some types of findings of facts and conclusions of law, that at least some no-fault divorces would be denied. And yet in the state of Texas, that does not happen. The state and the judges always, without exception, side with the petitioner. Now, what I also found to be very interesting is that in the Texas State Constitution, the very same Constitution that talks about protecting people's due process rights and other protections like that, the very same Constitution says this in Article 3, Section 56, prohibited local and special laws. The legislature shall not, except as otherwise provided in this Constitution, pass any local or special law authorizing, and if you go to number 13, the granting of divorce. Granting divorces. The legislature shall not grant any special laws granting divorces. And yet, what is it that we have in the Texas Family Code in Section 6.001? On the petition of either party to a marriage, the court will always 100% does grant a divorce without regard to fault if the marriage has become insupportable because of discord of conflicts or personalities, blah, blah, blah. The important thing to remember about this as well is that No evidence is needed for this allegation. All a person has to do is file a petition that says, my marriage is insupportable, blah, 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 and the judge will, without exception, 100% of the time, grant the divorce. What the Texas Family Code has in essence done, it has created a special law. Now, a special law is a law that favors a certain class of people. And in this instance, what it does, it favors the person, it favors the petitioner. The petitioner always wins. The respondent always loses, period. So you have a law created which goes against not just the idea of due process, but also violates the Texas state constitution regarding the establishment of special laws granting divorces. This is a special law that has granted a divorce for any reason, for no reason. The person filing for divorce can make up a reason. The person filing for insupportability may say, my marriage is insupportable because I, as a woman, either have decided to become a lesbian, or maybe I have now met a man who is richer and more handsome and in much better shape than my husband, and he listens to me when I talk to him. Or as a man, you may be able to invoke insupportability because you have been having an affair with your secretary who is 15 years younger than your wife, has no stretch marks, and she listens to you. She listens to me, and therefore my marriage has become insupportable because my wife doesn't listen to me. This whole idea about insupportability is garbage, and I will tell you point blank, it comes from the pit of hell. It is satanic, it is demonic. This is the exact same thing that Vladimir Lenin imposed upon Bolshevik Russia in 1917. The idea of unilateral, no-fault, forced divorce, divorce on demand, was actually first imposed in the 20th century on Bolshevik Russia by Vladimir Lenin. This is the exact same doctrine that we have in the state of Texas as far as divorce is concerned. Prior to that, there had to be a fault-based reason for divorce. Vladimir Lenin imposed unilateral, no-fault divorce on Bolshevik Russia so that he could impose communism, knowing that if he abolished the family, he would have a much better chance of imposing communism. The interesting thing about Vladimir Lenin's action is that within 10 years, society had fallen apart to such a degree that there was a national debate over whether these unilateral no-fault divorce laws abolishing, for all intents and purposes, marriage were good for society. We in the state of Texas have the exact same laws that Vladimir Lenin imposed upon Bolshevik Russia, and we won't even be honest enough to discuss the impact that it's having on our society. Furthermore, under Vladimir Lenin, they repealed the laws, they changed the laws. In the state of Texas, we have such august organizations such as the Texas Anti-Family Law Association, which defends these laws. We have divorce attorneys, which defend these laws. We have feminists, which defend these laws. We have men who want to think, I have the right to associate with whomever I want to and have sex with whomever I want to, who defend these laws. These laws are destroying society. These laws are unjust. These laws are special laws created that without exception, once again, without exception, favor the petitioner. The petitioner always wins. And the way that I say the petitioner always wins is that the divorce is always granted. And that's very easy to prove. If you can find me 3 cases in the last 5 years in which the judge has denied a petition, a request for unilateral no-fault divorce, please send them to me. Now, the interesting thing was I was at a meeting with some attorneys about 3 months or so ago, and the one attorney said, well, that's not true. I can give you a case. And I said, okay, so when was it? And she said, back in 1991. 1991. So here we're talking about 28 years ago, there was an individual case, and I believe the result of that case, nevertheless, was that the judge still granted divorce in the situation. This is such a huge constitutional issue that is actually written into the Texas GOP platform. If you look at plank number 334, the Texas GOP platform calls for the legislature to rescind no-fault divorce laws. This plank has been in the Texas GOP platform for at least 10 years that I am aware of. I first became aware of it when I was working on the Texas GOP platform back in 2012. It was already written at that time. And yet, my question is this: why aren't we doing anything about it? This past session we had two bills, House Bill 922 and 926, that dealt with divorce laws. One representative, Matthew Krause, sponsored those bills. There were no Republican co-sponsors. Not to any of them that I am aware of. We have a statute in the Texas Family Code that is completely unconstitutional in that it nullifies, it disregards all due process protections and the equal protection under the law to the respondent to the petition for divorce, both in the 5th and the 14th Amendments and in Article 1, Section 19 of the Texas Constitution. But in addition, it violates the establishment of a special law granting divorces, which likewise is in the Texas State Constitution, Article 3, Section 56. These laws have done immense damage to our society, to families, to men and women who have been forcefully divorced against their will, to children who have suffered the consequences of their families being torn down by these laws, which for all intents and purposes mirror those that Vladimir Lenin imposed upon Bolshevik Russia. We need to do away with this law, not only because it violates due process protections, but also because it is against the Texas State Constitution, which forbids the establishment of a special law granting divorces. Thank you.